a question-driven presentation with attorney Chad Gates. We want to thank him very much for being with us here today. Again, make sure you type in everything because the raise hand function and all of the audio has finally been muted. So please do make sure that you do that. So without any further delay in that, we will, of course, satisfy our lawyers with our required canned disclaimer, is that even though Chad today is an attorney, we at Advanta here do not, or our employees do not provide legal, tax, or investment advice, nor do we endorse or promote any products. All information today is being presented by us for educational purposes only, and all parties are always encouraged to consult with their attorneys, accountants, and financial advisors before entering into any type of financial investment. So now that we have that satisfied, my name's Alex Perney. I will be your moderator today, so I will be moderating all the questions that will be in the chat box that you will put in there. So please do make sure you get those in there often and frequent. I'm a member of the American Banking Association and American Trust Banking Associate as well, and I do hold my designation as a certified IRA services professional. So if you have any questions about how this stuff works, or if you have a question maybe legally about how something can function within an IRA or how maybe your investments can be structured like that, please do encourage you to let me know. I can certainly answer this for you. Chad has had experience with many of our clients and seen this work in the real world for many years throughout his career, I'm sure. So feel free to ask any questions specific to that, but I want to make sure everyone understands today that this is not something that you need to necessarily just use with regards to how an IRA works. We want to try to present good people and good co-hosts with us that can help answer some more general questions that you may have that maybe don't necessarily just pertain to your specific IRA assets, that pertain to anything in the real estate sector. So please make sure that you ask your questions with a broad scope, paint with a broad brush, get them out there, because this is a good time, without having to pay the hourly rate of an attorney, to get some good insight into a legal mind that has had a great deal of experience in our area with investing in real estate and handling real estate closings. A little bit about our presenter today, Chad Gates, partner at Ban Gates Dramas PL in sunny Sarasota, Florida, lifelong Sarasota resident and a member of the Florida Bar since '93, Ohio University BBA in Finance cum laude at 90, and Capital University of Law School at 93. He represents buyers and sellers of commercial and residential properties and advises investors on complex deal structuring in real estate, ventures and loans, and business deals as well. I see a few people asking questions regarding some audio. Let me just type quickly the number if you have any questions. All right. And just before we kind of jump into this, we do always want to make sure that you understand what our presenter will be presenting today does apply to any type of the plans that we do administer here at Advanta. Everything from traditional IRAs all the way to health savings accounts can get invested in real estate, do joint ventures, issue loans, hold mortgages, and the like of the scope of what we're going to cover today. So please make sure that you understand that we can really kind of try to help you with whatever you are looking to accomplish with your self-directed retirement planning in the realm of real estate. So not just the traditional Roth IRA, we can really span the gamut of many types of plans that can get invested in real estate as well. So you understand who Chad is, a little bit of a background on Advanta. We do have over 20 years of combined industry experience with Advanta. We have almost $1 billion of assets under management, and of course our great network of attorneys and CPAs such as people like Chad help us give good content and good information out there to our clients to make informed and educated decisions when it comes to what they're investing in and how they're investing their money. It's always a good idea to understand not only what you're investing in, but also how you're investing as well. So understand that the personal aspect of being able to reach out and access people like this is a great benefit to you as the individual and you as the investor. So make sure, again, that you do get some questions in there. We have yet to have the first one pop up in the chat box, so I'd encourage someone to break the ice with one. And if you'd ever like to schedule a consultation to review anything on this, all of our consultations are free. We will also host this webinar on our YouTube page, so feel free to go back and review it at your leisure. Also, the recording will be available for free as well. And just so you know, the contribution limits for retirement plans will be included in this. So we do encourage you, if you have any questions, take a snapshot of this, or it will be on our YouTube page as well, so you can get some good information with regards to your end-of-year tax planning and what needs to go where, and essentially how much you can contribute on a year-end basis for these types of plans as well. So Chad, with the first bit of it out of the way, I'd like to turn it over to you. I will kind of let this be a question-driven presentation, but I would like you to, kind of expound upon, what you would like people to know as well, because I'm sure there are many times at the closing table where you sit there and you're kind of rapping your knuckles on the desk, wishing someone kind of knew something that you knew that could have helped save them a lot of time. So I guess the first question I would pose to you is, what would you say the most common issue that you see with people that are kind of getting new into real estate investing would be when it comes to common issues and closings with real estate?
The last couple of years, there's been an abundance of people selling properties and claiming to have the ability to sell properties that actually don't. So we're seeing more and more contracts that come through the office. When we start digging into the actual sellers, we determine that seller who has signed that contract doesn't have the ability to sell the property without other people joining in on the contract or joining in the closing, and sometimes don't have the ability at all. So typically it comes out of an estate where mom and dad die and the surviving children own a house, and one of the brothers decides to sell it, and there's 3 or 4 other siblings that are involved that haven't signed the contract and haven't agreed to the deal. And we've had it happen a few times in the last couple of months where at closing these deals have blown up because we couldn't get the necessary signatures to conclude them.
Absolutely, and just to kind of expound on that, and correct me if I'm wrong, but in the state of Florida, a lot of people don't realize is that the ubiquitous term of executor of an estate gets thrown around a lot. With the state of Florida, we do have what's deemed as a personal representative that needs to be signing in the probate process and through the estate, correct? So it's not just one person that people need to look at. There's the whole family when there's an inheritor that they need to look at for the release and sale of assets in that estate, correct?
It's actually even more difficult than that. It depends on whether the property was a homestead of the individual that passed or their non-homestead. If it was their homestead property, there's no PR involved because in the state of Florida, homestead property transfers outside of the estate upon death by operation of law. So when that individual dies and it's their homestead, it automatically vests in their heirs. So their children would automatically be vested with that property. So there's no PR involved in that because it's outside the estate. If it is inside their estate, then yes, a PR is the person that has the ability to bind the estate and to sell that property. So we see contracts literally on a weekly basis that come in where somebody has signed and they call themselves an executor. That means nothing to us. When I see that, it's a big red flag to start asking questions about who they are, what are they doing, why are they selling this, and who do I need to talk to about getting real signatures that can bind people? I mean, the problem that we have as investors is we go out there, we spend a lot of time and effort to find property, and we finally find a property that makes sense. We want to make sure that the person who's selling us that has the ability to be bound so that they can't walk away. And you waste all this time looking at properties, and then all of a sudden you get a contract, and it's not a valid contract. You just wasted that time. So, we want to make sure that people know who they need to go to and who they need to get to sign these contracts.
Exactly. Now, within an estate like that, so essentially you're kind of pointing out a good point there, is that if the estate only contained someone's home, then you have a much more splintered path to go down, because if they had 5 children and let's say 2 of those children are deceased, you have a very large pool of people that potentially have their hand in that asset, correct?
Yes, and I mean you can have an estate that has multiple assets in it, including a homestead. That homestead would be outside of the estate because it passes automatically upon death, but you still have a probate regarding these other assets inside that estate. So you could end up in a situation where you actually have a true PR that is appointed by the court regarding that estate. That PR is signing to sell this homestead property, and the PR doesn't have the ability to do it because it's vested in the children or the heirs at that point in time.
Sure, and is that something that would come up in the beginning of a closing cycle, or was that something that you would find kind of like right when you're doing final title searches and stuff? Where do people typically find this, and what would be the best course of action? And kind of if you've ever done one of these things where you've bought through an estate, what kind of questions would you ask up front to make sure that you're protecting yourself and understanding what you're getting into from the beginning?
I mean, it's probably best to contact an attorney and let the attorney drive you down that path as to how to gather that information. It's kind of a strange conversation to have when you're sitting in somebody's dining room table trying to buy their parents' house, and you start asking them about whether or not they have the ability to buy or to sell that property. So, but what we need to know is, we typically find out pretty early on when we see a contract that has words executor, and that's a big flag for us to start asking questions about really what's going on. So at that point, we can go in and start, looking at what we need to do to get everybody who needs to sign on board and start making the phone calls and those types of things. If you are an investor and you're trying to get somebody to sign a contract, if you know that it was mom's home and mom died there, because usually people will tell you it's my mother's home and she passed away. That's the first indication that you're going to need to know who all the heirs are, and all the heirs are going to need to sign this contract. If they tell you that it was their second home and mom and dad lived up north, then it's a PR, and we need to start looking for a PR to sign that contract. A lot of times, though, what we find is that sellers or the survivors of these sellers, they get involved so early on that they're actually signing contracts to sell property prior to being appointed as a PR, or even on non-homestead property. So there's no authority for them to even be to bind that contract for them to sell it.
Yeah, that can certainly be a big issue with making sure that you understand who is liable, shouldn't say liable, who is able to sign that document in order to legally bind that deal together. And it kind of brings up an interesting point too, is that from my experience and what I've seen for investing with clients for the past 6 years, and yourself over, I believe, the past 26, if I'm not mistaken, years as an attorney. What kind of things would you say that would really kind of, you have this pool of assets that kind of comes out of the death of people, and in Florida, a lot of people like to come down here in the, say, autumn of their years, and then leave substantial amounts of assets in the state. They tend to become a big target for people that are doing wholesaling. Now, people will try to get a contract, a contract on a piece of property, and then in turn sell it for a markup on whatever the contractual price was. Are there any specific issues that you've seen with kind of convoluted trails of contracts, or people trying to do double closings that are really specific to the estate assets that you've been talking about, or anything that kind of would really segue well into that sector?
Yeah, I mean, wholesaling can cause some problems in a closing, in that typically wholesalers are making representations about the quality of the property and the value of the property to individuals who are from out of state, and they end up getting a contract for substantially less than the value of the property. Then they go out and they sell this property for $5, $10, $15, $20,000 spread, and the rub always is that the wholesaler doesn't want that shown on the closing statement because they don't want the seller to see it. But us as closing agents, we really want to show it on there because we want full disclosure. And what happens all the time when you have these closes where it's not disclosed, and then they find out later that the property sold for more, they end up getting irritated, and that's when people start threatening lawsuits and all the things that go along with that. But the bigger issue, again, I think, is that sometimes these wholesalers are getting contracts from these sellers, and the seller doesn't have the ability to bind the sale by that contract. They don't have the authority to sell it at that point in time, and then that wholesaler is ending up flipping that contract to an investor end user, and they really don't have anything. And you see these wholesalers asking for non-refundable deposits and all kinds of things that are just could end up being at risk, because if I assign you a contract and I don't really have a valid contract, then you don't really have a valid contract. And trying to get your money back from the wholesaler could be a problem. He might be gone by then.
Exactly. Have you ever seen something come all the way, let's say, to fruition with a closing where, for whatever reason it closed, and then after the fact there's been, continuity of the ability of whomever down that line of, let's say it was wholesaled a few times for them to have signed it, cause an issue after closing, or do those things readily
No,
pretty much get caught?
yeah, we figure that out at the title stage. So, when we do a title search and title report comes in, it tells us who all the parties are that we need to get signatures from. So it gets pretty specific because we go in and look at the will, we look at different things and determine who these necessary parties are. So that we don't have a problem after closing with people coming forward and claiming an interest in the property. And that's really the purpose of title insurance, is so that if somebody does do that, the title insurance company would step up and cover that claim. But the real problem is getting the signatures. You don't want to go out and spend all this time looking for property, end up in a contract on property that's not valid. So if you end up with, we see it in a lot of different areas, not only in deaths and probates and estates, but we see it in the world of LLCs and corporations too, where somebody has signed on a contract saying that they're the manager of an LLC and they don't have that authority. And that's a problem too, because if they're signing and they don't have the authority, then you don't have a valid contract.
Exactly. And there's some good segues into LLCs that I'm sure a lot of people would like to get into. Vandy asked a good question. We kind of jump into, people, in our industry that have a lot of experience in this, especially retirement planning and you dealing with investment properties. What exactly a PR is? It stands for personal representative, but I'll let Chad expound a little bit on what exactly that means in the state of Florida in someone's estate when someone dies, what a PR does, and what exactly that's important for you to know about.
Yeah, a PR for a simple definition or explanation of them would be that they're the manager of the estate. So when a person passes away, we file a pleading with the court, and in that pleading we ask for a PR to be appointed. And that PR could be somebody that the will designate as the PR, or it could be a family member, or it could be an attorney. That PR then, once they're appointed by the court issues an order appointing them, is the person that has all control of the assets related to the estate. They're the person that has the ability to buy and sell and liquidate the assets of this estate. Nobody else has the ability to do that.
Yeah, it's a good point. It's just one of those things, and again, like Chad said, a red flag for someone, especially if, and there's, good leads to be found in getting probate lists if you're kind of starting out with real estate investing, but be careful if you contact someone and they do indicate that they are the executor of an estate in the state of Florida, because the correct term and the correct, legal avenue that it goes down is with a personal representative in this state specifically. So it's good to understand exactly where that falls.
Right.
Kind of something.
Now
Sorry?
a lot of times what ends up happening is the estate hasn't been opened yet, so there's nobody been appointed. So, if you're an investor, you still want to get it under contract, but just know that you're going to have to get that contract amended at some point in time to incorporate this PR signature on it. So, most of the time people are wanting to sell property. They're not looking to do anything wrong. It's only when they do something that's improper that this really becomes an issue for us.
Yeah, and to kind of expound on that a little bit, it's also good to note that from the IRA perspective of things is that this even kind of operates a little bit farther outside of that realm, is that if you were to have a piece of real estate in your late father or family member's IRA and you were named as a beneficiary of it, essentially beneficiary IRAs directly inherit the assets of that account and the direct percentages, and you don't necessarily have to look at a PR from that perspective because it's the account holder that would direct the custodian to sign in that case. So if you do
Absolutely.
find someone that dies and they had an asset in an IRA or another qualified retirement plan, it does simplify things a little bit. If, let's say, they only had a homesteaded property and you were only interested in the IRA stuff can be cleared out a little bit faster because it doesn't necessarily have to go through all of the same rigorous steps in a probate and an estate as some of the other personally held assets do. So it's important to understand that not only is there a difference between the personal assets, the investment assets, and the retirement assets, but understanding what avenues you have to go to, and if you are looking to acquire some assets from a sizable asset pool, that some of them might be acquired and closed out a little bit quicker than others. And understanding who can sign, when they can sign, and how those can be conveyed is really important for you as the investor to understand.
Right. So an IRA, IRAs are easy because upon death in an IRA, like you said, it goes to the beneficiary. there's no court that needs to be involved in that transaction at that point. We file a death certificate, and then the IRA turns the asset over to that individual at that point in time.
Yeah, exactly. And I can speak to personal experience with Chad's firm with some sizable estates from clients that have passed and how they've handled it, and they do a great job with it. And also the ease at which that can be facilitated can be directly related to essentially who you deal with and how they are handling that. But for the most part, IRA owned assets, if you are fortunate enough to be the recipient of them in a beneficiary circumstance, can be cleared out a little bit quicker if you are looking to try to maybe put something to cash or exchange it out. You can do that in a quicker sense in some regards.
Right.
So now, issues in real estate. We've kind of talked about the direct issues with a big one, which is when people die, what do they do with the assets? How do we handle those assets? Now, some things that I've seen with the changing market is that there are different ways that people are investing in real estate. With the increase in the price of real estate, there gets to be a lot of different things happening. You see more wholesaling, people trying to move quicker because as prices increase, it gets more expensive to acquire real estate, people changing their strategies. And with changing strategies and changing attitudes comes a new set of issues. When you have people that have a certain market, you have certain issues. And when you have a certain market, you have these new issues. Now, I don't know if you're seeing any of this from your perspective, Chad, but at least back when the properties were first starting to be acquired from the REO book list from banks and other people when they were first starting to be acquired and they were very cheap and wholesaling was getting prevalent, are you seeing some issues kind of recycle from the downturn in the market to the upturn in the market, and now with another upturn? Are you seeing anything that that is happening again that you might want to say, hey, this might be a trend that would be an issue for people out there? Wholesaling is kind of a good one to throw out there, but I'm sure you've seen some kind of wacky stuff that's happened in both sides of the cycles.
Yeah, I think there's a lot of games being played out there, and when you have a market that's rising rapidly, people don't want to purchase the property as much as they want to just lock it up and try to capitalize on that gain. So you see a lot of people playing games with lease options and other things like that, where they actually take possession of the property for a fixed price with a certain time period in which they exercise that option, and then go out and try to sell it. They're not real buyers typically. They're just middlemen trying to play a game where the rising market's gonna be a windfall to them. So we start seeing in a massively moving market like we have, people getting into these weird fringes of trying to put deals together without actually taking ownership of them.
Exactly, and I had a client recently that happened to, where there was, they were trying to purchase a property and there were multiple people involved, and it was ultimately kind of a long convoluted string of people trying to control it that maybe didn't have either the best interest or the actual legal ability to control that. And ultimately, they managed to get it figured out to a fruition, but it was one of those kind of things like you mentioned earlier, where you get to the closing table and then people start screaming and locking doors. Unfortunately, it kind of got to that. So yeah. It's always good to know the chain of things happening. Now we have a question. Sorry.
Sure, go ahead.
Yeah, we have a question right here from Robert. He said he had a friend who claimed his brother tricked a notary into accepting another person in his place to sell a deceased parent's land and kept all the proceeds. Who is to blame? I'm sure that is a question that would require several follow-ups to get answered, but any insight on that one?
I mean, there's, notaries are in place to try to protect buyers and sellers, but there's been numerous cases in Florida and probably other states where notaries have went rogue and started doing things they shouldn't do and notarizing signatures that of people not in front of them and those types of things. That's why you want to use, established title companies, established law firms, so that, we have employees that don't do those types of things. And, you see these notary services and these signs around town for notary services for $25, and who knows what they're doing. And you could end up in a situation where you're getting a deed from somebody that's been signed by an individual. It's not the person that really they say they are. The notary claims that they are, and it's valid and gets recorded, and you end up with a problem down the road. So, Florida has a lot of fraud in it. We have a lot of people here. Seems like every guy or every person in the country that is running from somebody or something and is looking to take advantage of people, ends up somewhere in South Florida. So we got a lot of problems going on down here and a lot of fraud, and you just got to be careful. Things like power of attorneys. Power of attorneys scare us because there's a lot of fraud in power of attorneys. People claim to have power of attorney to do different things, and they really don't. And you see power of attorneys being used to defraud elderly people out of their properties and things like that. So they're something that's on our radar right now is power of attorneys. When we start hearing about power of attorneys, we want to see the power of attorney. We want to verify it. We want to talk to people. We want to call people and then start asking questions to make sure that they really do have this ability, especially if it's a non-party, a non-family member that has that power of attorney. So it's very common for a husband and wife to give each other power of attorneys if they're out of state so they can deal with their properties. But it's very uncommon for you to give your neighbor a power of attorney over your property when you live in New York so that he can do what he feels is right in Florida. So we had to look at those things and ask a lot of questions to make sure that that they really are being used for the purpose that they're intended.
Absolutely, and it brings up a good point too. I have personally, it's a kind of a good always to have personal anecdotes. Is I hold power of attorney for my wife, and I also hold a limited power of attorney in my parents and a few other people in my family, kind of the youngest and only one around to take care of that kind of stuff. From my perspective, if I need to do something, what is good for me to bring so that way I can show good faith and proper proof that I do have that to sign, so that way people don't have issues and it kind of ameliorates some of those concerns. If I were to walk in and need to, my parents get incapacitated, I need to walk in and show them my POA to sign something. What is a good way? What is you as an attorney, what do you like to see someone coming in, to have A to Z all taken care of? What's good for people to know on that regard?
Well, first and foremost is a power of attorney that's valid in the state in which it's being presented and executed properly. Second is I really want to see that attorney was prepared by an estate planning. That power of attorney was prepared by an estate planning attorney somewhere, because if you're buying it off of LegalZoom.com or going down to Office Depot and buying a form of it, that's what typically where fraud comes out of it. If an attorney's preparing it for you, it's executed in front of the attorney and his staff, you usually don't see a lot of fraud there. So with a power of attorney, we're going to ask questions about who you are and how you're related to these people, and we're probably going to call the attorney that prepared it and say, hey, Alex is down here trying to sell mom's property. What do you know about that? Most of the time they tell us, hey, yes, that's fine, not a problem, go forward.
Okay, great, because it's, as much as we like to talk about how to protect yourself from those things, it's also good to know if you do have that, how you can, essentially convey stuff in good faith, because, I like to think that not everyone is out there to get someone, so it's always good to know how to do things, in good faith and make sure that you are covering your bases if you do have to do something like that. So, one thing coming through, you say, power of attorneys are something that you like to watch out for a lot. And you mentioned something earlier that I think is a really good topic to touch on, because as we said, in changing markets, we see a lot of different issues arise. One market might be really prevalent for one type of issue and another for another. But you brought up lease options. Now, it's a very kind of kitsch term that likes to get thrown around there a lot. There's a lot of potential money to be made in them, and just like with anything, there is a right and a wrong way to pursue them. Chad, I want to know if you had any thoughts particularly on some of the big issues that you see with people trying to do lease options, what your kind of thoughts on them are, and if you could get any guiding principles to people that might be looking to get into doing those.
Lease options are a funny thing. We don't see a lot of them until all of a sudden one of these real estate gurus that you see on TV starts pitching them at a boot camp, and then all of a sudden you see a bunch of lease options come out. Lease options are really good when you have a tenant living in a property for a period of time, and they with an end goal of buying that property, and you're helping them get to that point. That's what lease options are really meant for. The investors that use lease options use them in a different way. They use them in a way that they can go out, lock up a property with a lease option with a monthly payment of $2,000 a month, and they anticipate they can lease that or sublease that to a tenant for $1,200 a month. And their play is really that they're going to make the spread between their lease price and the lease price of the subtenant. And then the second part of that play for them is the appreciation of value if it goes up. So, typically what we see in lease options is as long as the two parties are making their payments, everybody's fine with it. But when the strike date comes on for you to exercise that option, if the property has not appreciated enough to make it worthwhile for the investor to close on it, they usually walk away from the option and leave you sitting there with your property and no sale. And that's a problem for it. Now for buyers, you don't really have that same risk. It's the sellers that end up taking the most risk in a lease option.
Yeah, I can imagine. So, and another big issue is that with the Consumer Protection Acts that were passed through Dodd-Frank and several other laws, is that there are many issues, especially for investors that are potentially looking to do a lease option with someone, that you need to be very careful. And at least from my experience as a investment administrator and us, our company, as acting in a custodial capacity, we get asked a lot, hey, what's the best way to do this? I always refer people to an experienced attorney, not a guru, not someone that's done it before. Talk to someone that is experienced. Paying the few $100 for an hour of an attorney's time to go through this can save you immensely. Do you know by chance, Chad? I know the penalties are like crazy for doing a lease option wrong. If you give, equitable consideration for something and treat it more like a mortgage or something. Can you shed any light on that? Because I know they're kind of crazy.
I think all that stuff there's a good chance for a lot of that being repealed this next year. Some of it already has been repealed. But I know on the mortgage issue, the penalty is not only the loss of the interest, but the loss of the principal if you're found guilty for violating Dodd-Frank. So it's a pretty significant penalty. That's a lot of reasons why people don't want to own or finance anymore or do hard equity loans on primary residences, because it brings Dodd-Frank into it, and there's some disclosures and some things that you need to do to protect yourself. And if you don't do that right, the penalty could be losing all your money that's been loaned.
Exactly. So it's certainly something good to look at. And as Chad indicated, just like with anything specific to any industry, with changes in administration come changes in legislation, come changes in how it affects you. With regards to that, we will probably ultimately see some changes in that. Just to kind of head off to any kind of lingering questions people might have, at least from that respect, nothing's really come down the pipeline for most of what we see as the retirement administrators and custodians. Has anything really kind of filed down in the real estate legal aspects yet to y'all, Chad, with closings for real estate, or is it all just kind of ethereal at this point?
Yeah, it's not really. We have the same issues all the time, so there's not a lot of real changes in the real estate closing world that affect us.
Yeah, I can imagine. It's one of those things where they're all kind of specific to that. Now, one thing, at least, that I would kind of like to get into is that when it comes to structuring deals with loans, getting out of maybe necessarily the direct purchaser of a piece of property. We understand that, we need to understand who actually owns the property, who has had the ability to sign. If someone has a contract, did the right person sign that? Did the LLC have a right to sign and everything? And making sure all that is done carefully. But what about from the aspect of someone lending and structuring different loan deals for people that are buying investment properties? Let's just kind of forget about the owner-occupied stuff now. Are there any big specific issues that you've seen with people and the way that they structure loans to people that have caused any issues in the closing world? Maybe something like including equity participation in the in the note, or including some type of other clauses that have caused investors issues recently.
Yeah. So first I want to say I'm a big fan of private lending by investors instead of buying and selling properties. I think a lot of investors are better suited to be a lender and have less risk in it than they are to be an investor to buy properties, rehab them, and sell them and go down that path. So I think a lot of investors should be looking more towards lending than actual buying, because the returns are about the same, but the risk is substantially less. The problem with the equity participation is equity participation being where you take an interest rate up front. Let's say you take 12 or 13% interest on your money, and then when the property is sold, you get what we call a kicker, which is 2, 3, 4, 5 points on the back end, 20 points on the back end, whatever it may be, as to an ownership interest. The trick is to make sure that ownership interest or that equity kicker is not shown as interest. Because if it's shown as interest, you could end up getting yourself above the usury provisions, and that loan could be considered to be usurious, and we could have a problem, and you could end up in trouble. So it's a tricky situation to make sure that we don't put you into that situation.
And is usury, and for people who don't know what that is, a quick definition on usury is the amount of acceptable interest that someone can charge on a particular type of loan without violating local statutes and laws. Did I hit that one pretty correct there, Chad?
Yeah, and even the larger problem with usury is how you calculate out the number. So people, in Florida, on loan under $500,000, the usury rate is 18%. Over $500,000 is 25%. But if you get 18% interest on your loan and you collect interest on a 360-day period instead of 365, you're in violation because your APR for the year is over 18%. So we've got to be real careful on what we put in these notes as to what actually is considered interest. And when you start adding a bunch of these things in there and you start getting up towards that 18%, you could end up with finding yourself with a problem with this loan being under the usury laws. We don't see a lot of that. There's not a lot of litigation about it. Typically, it doesn't even come up until there's a foreclosure. But if there is a foreclosure, it's certainly going to come up at that point.
Absolutely, and best practices, I would say, are 100%, especially outside of an IRA, and making sure you have proper loan documentation. One thing, at least from my experience as acting in a custodial capacity and administrator of these accounts, such as qualified plans, is record keeping is key, especially with a loan, and with that, because your ultimate real recourse in that is an original copy of your note that they agreed to repay you on, and if there's any type of recorded claim against the property, and being able to foreclose or go through the process of needing to make a claim against the property is greatly facilitated by making sure that you very well custodize all of your documentation for that. So much in a digital age now, as everything's done on a computer, I can pull up an original copy of my deed, the mortgage that my mortgage company has, and a lot of things like that. But especially when doing stuff that's more of the investor base, or things that are done and maybe you don't record something, maybe it's just strictly an individual loan that doesn't have recorded security, making sure that you absolutely hold on to original documents, just kind of my 2 cents in the loan area is very, very advisable for anyone that's going to be operating in that area.
And beyond that, asking questions about what you're really getting into. Are you a lender, or are you an equity participant? So you can have a blend of the two. A lot of times people think they're an equity participant, and the reality is they're a lender. And a lot of times people think that they're a lender, and the borrower really thinks that they're an equity participant. So we need to be real clear about what your role is in this transaction. If you're a lender, you're lending money. You have no liability related to that property. When it's sold, you get paid back your interest plus whatever fees you have. If you're an equity participant, you don't get your interest for the loan. You get whatever your participation level is. If it's 20% of the profit, you get 20% of the profit. And you can have a hybrid of the two of those. So we got to be real careful that when we do these hybrids, that we keep them separate, that we keep the notes separate as a lender, and you also have an equity participant through the LLC or a joint venture agreement or whatever it may be. But we don't want to have a note that includes all those terms, because it could be considered the interest at that point, and you could end up in trouble.
Oh, that's a really good point to make. I honestly, in my time of doing this, I've seen it done all different ways, and a preferable method is always really good to see that. So having things separated out, not necessarily just saying, hey, just because I can put it on one document doesn't mean I should, is kind of the point you're getting out with that.
I mean, it's easy. Everybody wants everything simple, but sometimes simple isn't the best way to protect yourself. So, what you don't want to have is these big issues that come up that can cause you to lose your investment, especially if you're putting money out of your IRA into these things and you're trying to grow that. You don't want to lose it. And the fastest way to lose money in your IRA, other than bad decisions, is loaning money that exceeds the usury rate and violating Dodd-Frank and things like that. So you just want to make sure that you're careful about keeping it separate. So if you're going to go into a transaction as an investor, and you're going to have an equity position in it, but you're also loaning money to it, then let's keep the loan separate from the equity position. It's 2 documents instead of 1. It's no big deal. It's just a better way to do it.
Absolutely. And Chad, does your firm offer legal advice on determining usury and things like that?
Yes, we do. But my preference is to stay away from usury. Somebody comes to me and say they want to loan money to somebody at 18% interest. I say no, we're not going to do that. Loan it to them at 16% interest because you don't have to worry about it.
Exactly.
It's the calculation and the problem. And I don't know if you follow this, but during the downturn of the economy when we had the great bust, a lot of people were fighting their mortgages and their lenders based on usury issues. And the way that you calculate it, it's a very convoluted calculation. And there are law firms across the country that did nothing but look at these documents and determine whether or not there was an issue related to usury. We don't want that. We stay away from that. So we like to structure our loans for our clients in such a way that we're not even close to it. We don't have to worry about that.
Absolutely. It's very good stuff to stay away from. I get asked about it from time to time, and it's one of those kind of things where I give general guidelines, but I am by no means a expert in any regard to that. So I do like to always have good people to refer out to. Rose asked a good question. Does he know about 401k conversions? I'm sure he does, and I do absolutely as well. Very broad question. If you could narrow that one down a touch, I'd be happy to answer it for you. But that is certainly a question I am very well happy to answer for you. Or if it has something to do with real estate and legal issues, I'm sure Chad can chime in as well.
I think that up to you. You're the expert on that stuff.
Absolutely. So, need specific information. Well, Rose, I would say, give me a call, 727-754-9954. I can talk to you about 401k conversions till the cows come home. It is what I do. It's literally what they pay me for. So I am certainly happy to answer that for you. So now the last thing I'd like to kind of get into is what everyone wants to know about. We talk about legal protections. One good quote before we kind of get into a few nut and bolt questions is that a very well-respected and liked investor in the area, and I might say the nation, Pete Fortunato, has a very good saying about mortgages. Like Chad was saying, a lot of people are more apt to get into that as opposed to other things. He says you can't trip and fall over a piece of paper, and it really kind of goes to show if you are trying to get into something and learn things and you want to reduce the amount of risk and liability you have, being a lender, does certainly reduce your liability exposure in a lot of areas. By no means does it, keep you completely out of being sued in a lawsuit. As you mentioned, usury and deal structure and things still go into it, and you need to be careful and get good advice. But it goes to show that, if someone trips and falls, typically the mortgage holder is not someone that is going to be really involved in a lawsuit that involves liability aspects. Is that more or less correct, Chad?
Oh, that's absolutely correct. I mean, Pete is so right when he says that there's the amount of liability that you can take on as a lender if you get good advice and do the right thing compared to being an investor, buying a property and owning it with a tenant in it or owning it and trying to rehab it and sell it is night and day. I mean, it's just, there's very little liability as a lender. There is some risk of non-payment. But even that, typically, if you're doing a hard equity loan, you're into it at such a small loan to value, 50-60%, that you can, even if you have to take the property back, you can still recover your money and maybe even make a profit on selling that property. People don't want to do mortgages because they're afraid of the foreclosure process. And I think during the downturn, there was a lot of articles and news coverage out there about people being able to stay in these houses for 4, 5, 6 years without paying for them. Those days are gone. That's not happening anymore. The judges have caught on to what that scam was. They're not allowing it. So, if you're going to be a lender as a hard equity lender on a investment property, if it goes bad and you don't get paid, the process, it might take you 4 to 6 months and a couple $1,000s, but it's not something that is just overwhelming, and it's certainly something that I think is worth looking into. The investor side of owning property, that's where your risk is. You got risk in liability for things that happen. You got risk in liability for deficient products that you use to build the house. You got risk that your contractor didn't do it properly. You got risk that the building permits weren't pulled. I mean, there's all kinds of things that can happen, and workers' comp also. If somebody's working on the job and gets hurt and their employer doesn't have proper workers' comp, that can come back to haunt you. So there's so much more risk on the investor side that if you're not really good at it and experienced in it, you might want to stay away from it.
Absolutely. It's very, very good sound advice for it. And then anything, we're getting right up on the 1 o'clock hour, so we always want to make sure we respect everyone's time, including yours, for being a part of this. Any good, things to look at for, best ways to mitigate liability? What's, besides, just doing good practices, are there certain, everyone can do this type of thing that will, essentially help you cut down on your liability exposure in some aspects?
Well, there's two sides to it. As a buyer, I think you want to make sure that you are contracted to buy something that you understand what it is and you're getting exactly what you contract for. So you want to make sure as a buyer that when you go put a piece of property under contract that you're looking to make sure that all the improvements done to the property, if any have been done pursuant to a permit, and a permit's been pulled and been closed out. You want to make sure that you're dealing with the right person to buy or to sell that property, and you want to make sure that everybody that needs to sign at closing is on board for this transaction. As to liability, buyers really don't have a lot of liability unless they've reached a contract. On the seller side, we start worrying about things like improper repairs, inadequate repairs, repairs done without permits, failure to disclose known defects related to the property or the surroundings. That's where a lot of liability comes from over on the seller side. And I think when you're on MLS or whatever you're doing to look for property, and you see terms like completely remodeled or partially remodeled, or a new roof or a new AC, you need to start going into to most of the counties, I think, in Florida have the ability to go online to search for permits. And you need to make sure that the repairs that were done were actually permitted, because if not, you buy that property and it wasn't properly permitted, you could end up yourself with a situation with the county regarding those improvements. And then if you go to sell the property, it can be a problem for you then. And correcting that problem and correcting that permit issue after the fact is much more difficult and much more costly than it is to do it up front. So
absolutely,
I think you got to look at things like that. Be careful about fraud. Fraud is out there. We get a lot of different types of fraud. We get, forged certified checks. We get forged power of attorneys, forged operating agreements. We get all kinds of things that come through. So there's a lot of things going on out there. You just got to ask a lot of questions and just kind of be understanding of that. There's that you need to understand what's going on with the transaction and the people involved in it. And if it doesn't smell right, start asking more questions, because there's usually something wrong.
And for the most part, from what I've seen, and you can probably attest to this, is that if everything is on the up and up and everyone is clear with it, most people won't have an issue answering questions. If you're just asking in good faith and trying to figure this stuff out, it's time and time again, and we see this in the investment industry and everything, is that if questions are asked and pushback is given, that is a red flag in and of itself. Make sure that what you're getting into is transparent and, people are being upfront with it, because the more information you have, the more informed decisions you can ultimately make.
Right. If you're dealing with an end user who's selling their property through a realtor, most of these issues are vetted out before that realtor lists that property and goes down that path. We very rarely have any issues related to that other than liens or mortgages or something like that was outstanding that we didn't know about. Where we see this problem is in the wholesaling world. So a wholesaler goes out, contracts to buy a property, and then typically that wholesaler will either assign that contract to one third party, but a lot of times you'll see that contract's been assigned 2 or 3 times. And every time it gets assigned, you're further and further away from the person that ultimately has to sign this stuff. So you've had no contact with them. So you don't have any understanding of what this transaction in their mind is supposed to look like. And you don't know who they are or what they are or how their relationship is or any of that type of stuff related to this property. That's where we see the problems.
Exactly. I have a good question here. It kind of segues a little bit. It's kind of one for both of us to answer, and then I think we can call this a wrap. So Aaron asks, I want to paint a picture. I have a traditional 401k and want to convert it to a Roth, eventually thinking to buy and hold properties with the Roth IRA. What steps are needed to establish asset protection with this goal? Is creating an LLC owned by the Roth IRA needed? Still learning here. From the perspective of what we need, I always tell people the best way to protect your IRA assets, if you're buying real estate, is get a flesh and blood insurance agent and clearly explain to them that this is a qualified plan property and make sure that they write that policy correctly, that you have all of the applicable limits and coverages that you need, and that they can't come back in any scenario and say, you know what, you had someone trip and fall, we're not covering you because we didn't know it was an IRA, we had it written in your name personally. First and foremost, the biggest thing I can tell you. Secondly, with regards to an LLC, you could certainly utilize an LLC, and they do offer liability protections. However, if it is going to be a single-member LLC and you are purchasing it in the state of Florida, the Florida Supreme Court, and Chad can expound on this a little bit, does not offer the same liability protections they do to single-member LLCs as they do to multi-member LLCs and multi-partnerships. Chad, if you want to expound a little bit on that for what he needs to know on that regard, that'd probably be great.
Well, in an LLC, you got to look at the direction in which the liability is coming. So the issue between a single-member LLC and a multi-member LLC is related to the ability of one of your creditors getting to the assets owned by that LLC. So if you're a single-member LLC and you get a judgment against you for a bunch of money and you own some houses in that LLC, that judgment creditor could come and get the assets of that LLC pretty easily. If it's a two-member LLC, they can't. They have to get what's called a charging lien. And there's some protection related to that gathering of assets. The other side of an LLC is what flows through to you personally, and that's the block that we want. Is if you own an asset, say a house, and somebody puts some falls in it, we want that liability to be blocked and stopped at the LLC level and not be able to get up to your other assets. And that doesn't really matter if it's a one-member or a two-member LLC.
Gotcha.
The issue that I see with IRAs, and I think you have to insure them properly, because when you invest in property in your IRA, you're exposing your IRA to liability. So if you have a lot of assets in your IRA and you buy a house and something happens and they get a judgment against you for $1 million, they could get to your IRA. There's no block there for that judgment against your IRA. So we want to make sure that when you're buying things in an IRA that they're properly insured, because the insurance is really your stopgap.
And I tell people that time and time again, is that LLCs have their place. Do you necessarily need one? Is it the best use of your money? Making sure you have that, good insurance isn't cheap, and cheap insurance typically isn't good. Same thing goes with your legal advice, is that making sure that insurance policy is ironclad. One strategy I do tell people, though, is that from a legal perspective, IRAs, and I'm pretty sure I'm not the lawyer here, but I'm pretty sure I'm using this right, are considered disregarded entities in and of themselves from each other. So they are fairly insulary buckets for your assets from each other, meaning that if you have one house, let's say you have two houses in an IRA, someone trips and falls in one, that IRA that owns those two properties has the ability to have that lawsuit attached to everything in that, but it can't necessarily jump over into the other IRA per se, just in the normal course of a lawsuit, correct?
No, it's right. You're absolutely correct. If you have three IRAs and you have three different properties, and each in each IRA, there's not going to be cross liability there. It's only the bucket of assets that IRA owns that's subject to it.
Yeah, it's a good thing to know. Well, we're pretty much hitting this right on the dot. My watch has 1, my computer has 12:59. From a personal aspect, like I said, I have had personal experience with Chad Gates and his firm. I'm not just saying that because we have a good speaker on today, but I would absolutely encourage anyone in the Sarasota area, if you need his services, contact his firm. They do good work. We love having guests on here, especially ones that are experts in their field. I hope everyone got good information. We certainly covered a lot, everything from probate issues to current wholesaling issues to liability protections and current issues in the marketplace. So I'd always encourage you to check back at our learning center, get up to date on what's happening out there. His information's right up there. A few people had questions about Roth conversions and stuff. Give me a shout. Happy to answer those for you. But with that said, Chad, any last parting words?
No, appreciate you letting me be on. And if anybody has any questions, my phone number is shown. Just call me. I'm happy to answer them.
All right, y'all. Everyone have a wonderful end of your year. Today is December 1st, so we're in the final stretch of everything. Best of luck and have a great weekend. Thanks.
Thank you.